Evening, everyone, and welcome to this conversation by National Law University Delhi and Caravan Magazine on the quagmire of judicial appointments. Of course, we have a wonderful panel with us, and I'd like to thank all of them for accepting our invitation at extremely short notice. And thank you so much for taking the time out to come today. Also, I'd like to thank the Vice Chancellor, Professor Ranbir Singh, for supporting this event, and also Caravan, especially Hartosh Singh Bal and Munaza at Caravan for helping us with this and ensuring that all of you are here. Of course, we are gathered here today in the context of the judgment of the Constitution Bench on judicial appointments. Of course, there's been a lot that has been written and a lot that has been said, and we hope we can clear some of the clutter around many of the issues, both constitutional and political ramifications, its consequences on democratic governance and allied issues. And I'm sure that I'm sure all of you will have lots of questions, and we've tried to ensure that there is disagreement on the panel as well. Unfortunately, Ms. Kamini Jaiswal could not join us. She's taken very ill, and otherwise it was supposed to be 2-2, but I think now we will have Ms. Ramchandran and Ms. Diwan opposing, I guess, disagreeing with the judgment, and Professor Bakshi will lead the charge on defending the judgment, I suppose. And I will join ranks now with Professor Bakshi on that, and so that we can even things out a little bit. And a whole range of issues in terms of what the second judge's case decided. Is primacy a basic feature of the Constitution? Is primacy the only way to ensure independence of the judiciary? And what happens, and importantly, questions around the basic structure itself. And I'm sure Mr. Ramchandran will address that, and he's written about it, about why we must be skeptical of the doctrine itself. And I wonder if the judgment gives reason enough to doubt the doctrine once more. And I'm sure a wide range of issues will be debated today. The format is we'll have each of the three panelists speak for 15 to 20 minutes, and then we'll have a conversation amongst ourselves for about 30 minutes, and we'll then open the floor for questions for about 40 minutes. So that's going to be the format. If I may first invite Professor Bakshi to give his opening remarks.
Thank you very much. Thank you, Mr. Vice Chancellor, Professor Pandey, distinguished faculty and students, distinguished co-panelists. And yeah, it's warm-up time. Come here, Mr. Ramanathan, you're sitting far off. There's plenty of space.
The seats here.
You can still exit whenever you like. And I know, I'm very pleased. I didn't know about this Center for whatever public law. I congratulate you on organizing this debate, but I'm sure you will other events. I'm very happy that there is a center. Normally, national law schools have more centers than the faculty. I don't know the position in your case, but certainly there are fraudulent centers and there are not fraudulent centers. And I hope you are the right one. Anyway, make it right by being here. Hereby. Very good. Now, I don't know how many of you would have read the judgment. I have only 14, 15 minutes. I try to read. I can't read what I've written because I write very badly, if you can see that. Therefore, I'll ad-lib more or less. I hope that most of people here are law students or lawyers, and therefore have presumably read the head notes, if not the judgment. I'd urge you to read the judgment without it makes no sense. And we are 2-2. I don't know whether initially I was only in the position of Justice Chalmeshwar, who dissented in 4-1 judgment. But now I've got a distinguished note with me, so 2-2, and you will be the judge of judges. And that's first thing I have to say, that judging the judges is an awfully difficult task. And don't you believe just because you happen to be a professor or a student in law school, or happen to be a distinguished lawyer like Tattoo or many others, or you published a few treatises on law, that you are able to judge the judges. Socially responsible criticism, SRC, of judges is very rare and very difficult. And I can speak with an experience of my entire life before me, although I'm quite young, but nevertheless. I've encouraged my students to undertake SRC, but I've practically failed. Most criticisms you hear of any judgment are partisan. They don't appreciate the internal convention of the judges. They don't appreciate the constraints on judging. They don't read the arguments presented before the judges. They simply look at some parts of the judgment, or even without looking at any part of the judgment, they make up their mind. That is not socially responsible criticism. So I hope you will read the entire judgment carefully, as I've read already 3 times over. And I made a mistake, because I can't write very well after this talk here. And I made a mistake. I attributed to Justice Joseph Kurian, a statement was made actually by Madan Lokur about eminent persons. I corrected it now in my paper. But it just shows you must read the judgment very, very carefully before you open your mouth to criticize the judges. The judges themselves study a lot more in order to give a judgment. And their judgment stands for all times to come. And therefore, and it is public document, it's not classified. Therefore, it's a serious business. Now my time begins. It's a long page, I don't know where it is. Yeah. The first, let's survey the criticisms made of the present case. I'm talking with 2 distinguished people here. Justice Chalmeshwar is right in saying in dissenting opinion, a solitary dissenting opinion, that the entire world, as it were, was waiting for this judgment as to what the judges ought to do. And let us take it as a good starting point, that we're all watching for it. And it has come. And it has gone. It's no longer news. We're discussing it too late. The government apparently has accepted the judgment. And today the hearing began on the collegium system. So it has come and gone. And we are meeting to still evaluate. Scholars always speak after judges speak. And they can pick and choose their time to speak. They can speak after 2 years, 3 years, 4 years, 5 years, or not at all. So we are very eclectic people. But I'm glad for this discussion. It is still contemporary, it matters to people. Justice, who was it? He said in one of the judges' cases, First early said in the first judge's case, which I'm glad some of the judges have noticed, particularly Chalmeshwar, Brother Chalmeshwar noticed it, and quoted from him. But it's been with me for a long time. And he essentially said that this is a fancy creature, independent judiciary, for the lawyers and judges. This doctrine is not a doctrine which people of India care about. What people of India care about is speedy justice, efficient justice. They are not concerned with how judges are appointed or whether judges are independent or not. Now, the only bar of this Fazli doctrine, long time ago, was Chalmeshwar, Justice Chalmeshwar. And 4 of the judges did not agree. Now, what are the criticisms? One of the main criticisms is, and these people have studied it, but there are many people who speak without study, or they agree however. The unstudied people criticize judgment on the ground that it breaches parliamentary sovereignty. And there is no such thing as sovereignty under the Indian Constitution. It's a fact of life. We're celebrating 70th year or something very shortly. The Constitution provides only for supremacy within the appointed sphere. Parliament is supreme in its own sphere, so is judiciary, so is executive. There is no any organ which is supreme, sovereign. Only the people of India are sovereign. Therefore, this criticism entirely misappropriates the idea of constitution. This is not the idea of constitution. If Herbert Lionel Adolphus H.L. Hart was more literate, he would have a footnote to Indian decisions, because Indian decisions in 1951, Supreme Court says, in the Delhi Laws Act case, advisory opinion, first advisory opinion 1951, it says precisely what I'm saying, that no power under the Constitution is sovereign. And when people are sovereign, Justice Gatka in Union of India versus Cole says people of India are sovereign. Justice Venkataraman in second judge's case says there are two kinds of judges, people's judges and judges' judges. Those appointed by the judges and beholden to them, and people's judges, those appointed ultimately by the people. And he thinks president represents people, so he thinks president now, therefore. And in the present situation, president does represent people, I think so, to make a non-political comment. So, in a sense, the president so in a sense, everybody is supreme within the appointed sphere, and no one sphere is sovereign. That is the first point. Therefore, that's a facetious criticism to say our Constitution makes a distinction between constituted power and constituent power. And very simply, the distinction is this, that constituted power shall act within its own sphere. And constituent power, the power to change the Constitution itself, which lies with the people. Although our Constitution does not provide for referendum. That's a larger area, I will not go into it, but forget sovereignty. That's a stupid criticism. That has nothing to do with the Constitution that now exists or has existed for the last 70 years. It may be your wish list that somebody should be sovereign. That's, I'm not concerned with your wish list, that's as you are not concerned with my wish list. The second thing is, very quickly, the second thing is, that if you look at, now I know Raju does not believe in basic structure. Good luck to him. And he argues very passionately there should no basic. Good luck to him. But there is a basic structure. Supreme Court has laid down the law. It has been there for, whether Raju likes it or not, take the law of the land. And after Keshanda, there have been several decisions, which have been Nagaraj and another case. The Bombay explicated, you all know. But the deep argument about basic structure is what, as Anup said, what basic structure contains and what does not contain. And whether independence of judiciary is a part of the basic. Independence of judiciary is a part of basic structure. So has said the government, successive governments of India, successive jurists, successive lawyers, before the court, outside the court. The only question is the NJAC violated both the amendment, constitutional amendment, 99th amendment then, and the law. And the act. I'll come to it after time. So that is the basis of existence. And why is it existence? Some people say Democracy is a funny discussion going on in public. Some features are more superior than others. So democracy is more important than independent judiciary. Where do you get that from? First of all, you argue this way because there is a basic structure. Then you come into a box and then you argue which is what. And complete nonsense. All basic structures, I like listen. I withdraw the word nonsense because there's a patent pending. That is Justice Kaju. I don't look for any of his motions. So I withdraw that word. That is non-hyphen sense. That doesn't make sense. I call Kaju jurisprudence the cashew nut jurisprudence. I've written on it, that's different. But interestingly, sending me now is the articles. All of a sudden, you are also a recipient of that by email. Very interesting. Very interesting. But he is not here, so let's not discuss it. It is a strange argument. What is the relationship between basic structure, essential features? Is a very important question, no doubt. What is basic structure? I say basic structure is only one. That is judicial review. I always tell my students when explaining Keshwan that judges their constitutional striptease. And they shed one garment which sexist, but don't mind it. The men also do striptease anyway. It's a gender neutral term. They took out the shirt, they took out the jacket, they took out the trousers, they took out this mojans, everything. One garment they refused to shed. Which is that garment? By which they cover their, what we in India we call private parts. For where did you get this private part thing? I don't know. Private part. Or if you want to be little less, little more vulgar, you would say members. I don't know where you got the idea of members. But that is judicial review. Judges' power to say what the basic structure is and what essential features are. Judicial review, I think, is the basic structure. The rest of it is foreplay. So you find in Mineral Mills, Chandrachud going through all the 17 and 24 amendments, saying everything is well. It's not 24, 20th amendment, everything is well. Or take part. He said, I consider this, I consider this, that's the basic. Even if you might say part is basic, the judges don't think. So that's that. Get it right. What is basic structure? Is judicial power, judicial review process and power. Independence of judiciary is an essential feature. The question is quite right, whether it's unopposed it, whether a collegium. Now why was collegium wrong? According to their lordships. Collegium was wrong. According to 4 judges. The amendment was wrong because consultation under Article 124 and something else meant consultation with the Chief Justice, the concurrence of the Chief Justice of India in this case. Paragraph 21 of the judgment clearly Justice Kerr says, clearly, a huge paragraph, but he says summary, one point. He says, I asked Attorney General to concede that independence of judiciary is a feature of Constitution and we shall not violate it. But he said no. Well, I'll argue the case. I'll argue the case and prove to you that second judge's case, third judge's case is wrongly decided. How will you argue this case? When government of India, and that's continuous, we are not referring to political regimes, and the government of India in the second judge's case said, we always followed the justice of India's primacy. And out of 400 appointments, affidavits by the secretary law, out of 400 appointments, we have only made, I'm running my time, 2 minutes more. I made only 4 or 5 appointments, but not contrary to CGI. So the government accepted it. Third, judge's case, they came before the Supreme Court in advisory opinion, and they said, my lord, we don't seek a review of the petition. This is not a review petition, it's an advisory opinion. We just want to cross the T's and dot the I's of the second judge's case. We accept the second judge's case. For 20 years they accepted this judge's case. Now, if they want a review is available. Now, curative is available also. They didn't use any of these procedures. So I don't think, and I conclude, I have so many things to say, but we'll follow the discussion. And I cannot read anymore. The other argument that is made is, so I have never heard, I could not get the argument. Other view, I said, but the judges appointing judges. Only in India, judges appoint judges. That's a myth. Apart from United States, in most cases, the opinion of the Chief Justice is more or less treated as binding by Lord Chancellor in the UK, but so-called mother country, yes? Manmohan's mother country, Manmohan Singh's mother country. So it is there. It's not political, no political limits. I never make them. So if I make them, correct me. So this is not a judge's appointed. The question is whether the judges should have, Chief Justice of India should have primacy, and now the collegiate primacy over the president. And the answer of the Supreme Court has always been yes since 1990 or something. And second judge's case. So these judges appointing judges don't go by the processes. And they have given instances after instances where judges' judicial primacy is the settled norm in the countries in which it is said not to be a settled norm. Oh, why do you worry? So it's a political comment that you can make, of course. You are free to make, but political comments are not comments. The observations by busy people made off the cuff, they are not worth a scholarly attention. So this is not worthy of the opposition. Finally, then, I would simply add the Attorney General, who was very aggressive, the Law Minister was very aggressive. They did not take my considered suggestion at the consultation of jurists that they should go for advisory opinion. Where there is give and take between judges and the executive. They won't hear. I even formulated 3 questions that the President of India may ask on 18 July. Supreme Court has now converted it to partial advisory opinion. That is, it has said, independence of judiciary, but any difficulty with collegium, you come and make your suggestions. Now, I'll end with this. So everybody is going to the Supreme Court. Nobody is going to Parliament. Of course, it's not a session that bad elections, all that, whatever. Parliament can meet a national emergency. If the judgment constitutes national emergency, then you could have, if the judgment gives Parliament to provide for a judicial commission. Don't make a mistake. It does not take a plenary power. It only says you must not touch the independence of judiciary, primacy of the Supreme Court justices. And one judge goes so far as to provide an alternate collegium. I forget his name just now. I think it's Chandrasekhar himself or somebody else. That not the collegium proposed by the Act, but collegium that proposed by the court, where all the judges of the Supreme Court will be consulted out of a panel of 6 of 3 and names, which will then go to President and they will choose one. So, Parliament's power to pass a collegium is not affected by this judgment. But the only condition that is put is it should not ask the Supreme Court to overrule the past precedents. A larger bench can of course do it and has done it in the past, but only twice in the history of Supreme Court. The full court has said, but it not beyond the bounds of imagination. So an advisory opinion is now being partially undertaken by opening hearings that have happened from today. Will you tell us what is wrong with collegium? This is my last point. I have to talk too much. Simply, the judges say, are going to say, mark my words, I may not be here in this word, but you check it out. What judges are going to do? I'll tell you now. Judges are going to say, no question of accountability or transparency in appointments. We will mind our own business, you mind yours. But we'll go by certain standards, so the discussion does not give rise to the impression of abuse, not that it is abuse. And citizens of India do not know which is the superior system. A lot has been said about collegium, and a lot might be said this evening. It may be right. Chalmeshwar and Lokura said a lot about collegium system. They may be right. There is something wrong with collegium. But did we know how Mr. Bharadwaj, the law minister, appointed judges? Did we know how successive law ministers appointed judges? Did we know how Kumar Mangalam appointed Krishna Iyer? Now, of course, we know. So, citizens of India do not know either way how judges are. Certain people are appointed judges. They will never know. They will never know whether it is. So, don't expect anything out of this collegium hearing, excepting making it a little bit here and there transparent. It's certainly not going to be so transparent as Freedom of Information Act requires. And political parties know very well that they are not going to follow, they obey the Freedom of Information Act. And they are not going to tell you who your legislators would be and how they are selected. Similarly, you are never going to know as citizens who your judges, how your judges are selected. But there will be some here and there adjustment made in the collegium, and it will be a good thing. Thank you. I have spoken for too long. Thank you very much.